In July 2024, Defendant Daryl Jarrell was charged with 2 counts of trespassing in the 14A District Court of Ann Arbor, Michigan. He was formally arraigned on July 24th, and on August 7th, his case was scheduled for a pre-trial conference before Judge Cedric Simpson in the same court.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Jarrell. Please state your name.
Daryl. Okay. And where are we on his case?
Your Honor, we have not had contact prior to today. I think the number we have for you is
I don't have a phone. So whoever gave you a number, it was invalid.
Okay. So I'll need to figure out a way to get in touch with him so we can go over the case together. If I give you my number.
What is?
You have a P.O. box?
I don't have a phone. I have on the center. Use a P.O. box, I think.
Okay. Do you have an email address?
No. I'm under the radar. I don't use electronics.
All right. So you guys are going to be trying to figure out a way to get to make contact with each other, right? So.
Yeah.
Okay. So the reason I say that is let me just do this. Let me give you a little bit of time so that I'm going to turn this out to September 4th, 2024, 9 a.m.
What's the holdup? It's trespassing.
Pardon?
I don't understand what the holdup is. It's trespassing.
What do you mean what the holdup is?
This is it's an arraignment, right? Or a preliminary exam?
No. You're not charged with a felony, so it's not a preliminary examination.
Right.
You were arraigned in this on July 24th.
Mm-hmm.
They set this date. Your attorney hasn't been able to talk to you about the cases at all.
Okay.
So I'm trying to I can set it for 2 weeks out.
Yeah.
But the problem.
I'm tired of the state. I'm ready to leave this state as soon as possible. It's trespassing. I could technically leave and you guys could issue a warrant as long as I don't return. You can just kiss my ass. This is
you know what? No. I'm going to tell you what. You don't come in. You don't. Okay. That's contempt. That's 93. Keep going. That's another 93. That's another 93. That's another 93. That's another 93. That's 6 93s consecutive.
During that hearing, Judge Simpson attempted to schedule another pretrial conference to allow Mr. Jarrell additional time to communicate with his public defender, who had been unable to contact him due to Mr. Jarrell not having a phone. Mr. Jarrell responded with a profanity-laden outburst directed at the judge. As a result, Judge Simpson sentenced him to a total of 558 days in jail for contempt of court. Under Section 600.1701 of the Michigan Compiled Laws, judges are authorized to punish disorderly, contemptuous, or insolent behavior that disrupts court proceedings or undermines a court's authority when it occurs in the judge's immediate presence. Section 600.1711 further allows such punishment to be imposed summarily, meaning immediately and without separate proceedings, when a contempt occurs in open court. Mr. Jarrell's conduct clearly fell within this category. Section 600.1715 sets the maximum punishment for a single act of contempt at 93 days in jail or a $7,500 fine. Judge Simpson imposed a maximum sentence for 6 separate acts of contempt, totaling 558 days. Shortly afterward, Mr. Jarrell's counsel filed a motion seeking modification of the contempt sanction, and a hearing was scheduled for August 13th, 2024, where counsel argued for reduction of the sentence.
It does call the cases of the people versus Daryl Jarrell.
Ron Brown appearing on behalf of Daryl Jarrell, Your Honor.
Good afternoon, Your Honor. Daryl Jarrell.
Defense counsel has filed an emergency motion to attempt to purge the contempt in this matter.
You have.
And I first give the floor to my client.
Pardon?
I'm giving my client the floor.
Your Honor, there's no excuse for what I've done, man. I lost my composure and I directed my frustrations at you. I apologize for being disrespectful to you and your court and wasting time with the people. Hopefully you accept my apology and reconsideration of the time you've sentenced me to. Thank you.
Your Honor, we have referred him to our aimed social work division to help him work through in some of the personal issues that he's going through that culminated in his outburst in court. You've been a judge for a very long time, set a very high bar for people as they appear before you. I think we communicate differently. Some people, even though it's socially inappropriate, use profanity, and profanity can be used as an attention getter. And I think it got the court's attention, but he's in need of services.
Oh, he did.
He's in need of services, Your Honor. He's in need of services, and we're trying to sort through a plan to present to the court, if you would accept his humble apology to help him move the cases forward.
Anything from the people?
Well, Your Honor, we were all present for it. I had a chance to review the video. It's actually worse than what the court noted in the record. I'm sure the court's has seen the video, but it was worse than what the court noted. I will leave it to the discretion of the court, but if there's going to be a modification or change of the sentence imposed by the court, I would certainly like there to be a plan in place for Mr. Durrell.
Mr. Durrell, what was going on with you?
Well, there's a lot of issues that I'm under currently. One, I'm unemployed. I can't obtain a driver's license. Without those, it's hard to provide for yourself. The charges, once we get into it, you'll see that they're frivolous charges. They should have never been brought to the court's attention. They're minute trespassings that aren't even trespassing. I used an easement for one, and the other one should have been dismissed. Just frustrations, man. There's no excuse for what I've done. You wanted an in-depth look. I shared some things. I mean, it falls on me, man.
No, it does.
He realizes that this case, many other people are watching, and how the court handles it. We're hopeful that others won't use this as an example to act out as well.
Well, but from the very beginning, the one thing that, as Mr. Brown correctly points out, I've been doing this a minute. And, Mr. Durrell, you were in my court, and I watched you because you were sitting in the back. And you were sort of a dichotomy of things for me. Because as you sat back in the back of the courtroom, you sat there very respectful. You had your ball cap on. When you came through, you took your ball cap off. You sat in that back row, just patient as all could be. When you came up, you again, initially it was fine. You were maybe upset by the charges, but a lot of people were like that.
Right.
It was going fine, and I could overhear, just so that you understand what I was trying to do, I overheard, as you were talking to your attorney, that you didn't have a phone.
Right.
You didn't have email. And more than anything in the world, I was worried that you weren't going to be able to have adequate time. I would have just normally set it 2 weeks out, then whatever. And I was trying to give more time, not to delay it,
Yeah.
but to try to make sure that if you had to get in touch with Ms. Perrone by letter, you guys had to do that or do whatever,
Yeah. See, I was thinking
that
about the other.
there be time for that to happen. And that seemed to aggravate you, but I think, when I look at it, you were aggravated because you thought the system was kind of dragging out.
Good.
But I was doing that for your benefit.
My apologies. I'm again misunderstood.
And so then when you wanted me to, then you wanted it done sooner. So then I said, okay, I just said, well, move up to date. I didn't know it wasn't going to be helpful for you, but what the heck? And then
At the hearing, Judge Simpson explained that he intentionally proposed setting the next pretrial conference farther out than usual because Mr. Durrell did not have a phone, and the judge wanted to ensure he had sufficient time to communicate with his attorney by mail. Under Michigan Court Rule 6.610, a district court judge may require the prosecutor, defendant, and defense counsel to appear for a pretrial conference before a case proceeds to trial. In practice, these conferences serve as case management hearings where matters such as discovery, motions, plea discussions, scheduling, and the status of representation are addressed to move the case forward efficiently and fairly. Hey, Mr. Durrell's attorney had been unable to reach him. By delaying the pretrial date, Judge Simpson was acting to protect Mr. Durrell's constitutional right to effective assistance of counsel. as established by the U.S. Supreme Court in Strickland v. Washington, 1984. The Sixth Amendment guarantees more than the mere appointment of an attorney. It guarantees a meaningful opportunity to consult with counsel. For that reason, rather than the typical 2-week scheduling window, Judge Simpson proposed setting the next pretrial approximately a month later to give Mr. Jarrell and his attorney a realistic opportunity to communicate.
I've had people go off in front of me before. Doesn't bother me. It's going to happen, I guess. But you just got yourself worked up to the point that as you were headed down and out, I'm just thinking, you're not, I don't know why you want to battle. It's a battle you can't win.
Right. Silly me.
Yeah, silly, stupid. There's a lot of words. Maybe start with that because it didn't make any sense.
None at all. You're right, man.
And I'm going to tell you something. And I'm not saying this to embarrass you because you're in good hands with the folks at the public defender's office. You need a break, right?
Yes, sir.
You need something to go in your direction.
Yes.
Yeah. And it seems everything, you can correct me if I'm wrong, everything you had been doing, none of it was quite working out. Trying to get rid of stuff. This was one of the things you wanted it done and gotten rid of so you could try to move on to that next thing.
Absolutely.
And I'm not saying this again, I'm not saying this to embarrass you, but sometimes things get tough. You get yourself wound up, you get to a point, and then for a brief moment you regret it. You're not sure where to head. Am I right?
Yeah, sometimes.
And I think even that day, for a brief moment, you regretted what had happened.
Absolutely. As soon as I said it, but I was fueled.
And it's because when you got back there, and all of a sudden that door shut behind you and locked up, you realized something.
Oh, man.
Yeah. And as it was described to me, right or wrong, you were sort of laying there on the floor crying.
Wrong. I was sorrowful.
Look.
I may or may not have.
No,
I don't
listen,
recall.
just listen. There's no embarrassment.
Mhm.
There's not. I got it reported to me
Right.
because I was worried about you. I
Right.
didn't. Nobody was trying to say to embarrass you or do anything. You had gotten yourself to a certain point. Something got out of control. You took a circumstance that was kind of bad, made it even worse. Now you have to figure out how to get out of that.
Right. Absolutely. Yeah, for sure.
Okay. You had left here that day. You don't have a place to stay, do you?
No, I'm currently homeless.
Yeah.
The Delana Center.
Pardon?
The Delana Center.
But are you there most of the time?
They have a waiting list period.
Yeah.
So as long as you continue to check in, I think they do a triage. Lets them know that you're interested in a room there. They'll continue to screen you, and when one comes available, they'll offer it for housing. Until then, you sleep wherever you can, couches, wherever, tents, bridges, parks. As long as the cops don't push you along,
So the reality is you didn't have a place to go, right?
Oh no, I don't have a place to go. No.
All right.
Judge, he's even sleeping.
Pardon?
He was sleep deprived. He's sleeping. He's got a roof over his
I probably
head.
was sleep deprived a little bit too. Man, I couldn't stop falling asleep. Did you notice that? Couldn't, man.
I just thought it was my relaxing voice and personality. Mr. Allen, actually today, you look a whole lot better than you did that day.
Thank you. I feel better too.
Before you came in, when was the last time you ate?
I ate probably the day before.
So you hadn't eaten that whole day.
No. I actually went to eat, but I didn't have enough time to jump on the bus and come back, so I skipped it. I think I may have had some donuts for breakfast, though.
Okay.
I think I may have.
What do you think I would do with you after what you did?
And you can do anything you want with me, Your Honor.
Oh, I know I can.
What I would like you to do for me is to let me go, and we'll have continued scheduling of the September 4th date. and you'll see that I've told you the truth about the charges that are pending. They'll probably even get thrown out by then.
Pardon?
Once the prosecutor reviews them, they should probably get thrown out.
Well, probably you're about to try to make another mistake. And that is you're trying to practice law, even though it's about your case and you don't have a law degree. Why don't you leave it to the experts that are around you?
And,
Yeah.
sounds good.
I think he's suggesting that you suspend or hang it over his head. Contempt, if
Okay,
not
was that we sent him in?
purge, Your Honor.
I can't just let you walk away from it. What you did is, so that you understand, this really isn't about you or me. It's about you.
Yeah.
But it isn't about me. You can say all those things you want, but the one thing in the past 25 years, I will tell you, I do not let people just disrespect this institution and walk away.
Right.
It just won't happen with me, and I'm sure Mr. Brown has told you that. I just don't.
Okay.
I understand, however, and balance that against sort of where you are and what you're trying to do. So we're currently set for September 4th at 9 a.m. What I'm going to do regarding the contempt, I'm going to work it this way. I will grant to a certain extent the motion, and I'm going to reformulate the 558 days that you talked yourself into. And when you're back there thinking, think about this, how you took a case with a maximum 30-day sentence and parlayed that to 558 days.
Right. Oh, goodness.
So what I'm going to do is take the 558 days. I will indicate defendant is to serve 93. I will give him credit for the 6 that he's been in and suspend at this time the balance.
Thank you.
When we come back, so it's down to 93 now. When we come back on the 4th, I'll consider whatever else I might do regarding that sentence.
Thank you, Your Honor.
Whether or not you serve the rest of it is going to be dependent upon your behavior, how you come into court.
Judge Simpson ultimately reduced Mr. Jarrell's contempt sentence to 93 days, the statutory maximum for a single instance of contempt. He credited Mr. Jarrell with the 6 days already served, as Mr. Jarrell had been jailed immediately following the contempt finding at the prior hearing. The judge then suspended the remaining 87 days, contingent on Mr. Jarrell's behavior for the remainder of the criminal proceedings. When a sentence is suspended, the court imposes a punishment but holds part or all of it in abeyance, meaning the defendant does not serve the suspended portion unless certain conditions are violated. In this case, Judge Simpson retained the authority to reinstate the remaining jail time if Mr. Jarrell engaged in further contemptuous conduct, but he did not require him to return to jail at that time. Mr. Jarrell later failed to appear for the rescheduled pretrial on September 4th, 2024, and again on October 18th, 2024, prompting the court to issue a bench warrant on that date. He did not return to court until October 14th, 2025, after being apprehended on the warrant. Ultimately, both trespassing charges were dismissed in December 2025. This case illustrates how quickly a routine misdemeanor proceeding can escalate into a significant loss of liberty. Courtrooms operate under strict rules of decorum, and contempt exists to ensure proceedings can continue without disruption or defiance. Once Mr. Jarrell's frustration crossed that line, the focus of the case shifted almost instantly from the underlying charges to his behavior in court, exposing him to more than a year of potential jail time. Judge Simpson's later decision to reconsider the contempt sanction underscores an important principle. Contempt is a powerful tool meant to preserve order and the fair administration of justice, not to punish unnecessarily. By reducing the sentence to the statutory maximum for a single contempt finding, crediting time served, and suspending the remainder based on future conduct, the judge recalibrated the punishment to serve its proper purpose. The decision reflected both a firm defense of the court's authority and a recognition that additional incarceration was not required to restore order and move the case forward. If there's another courtroom interaction or case you'd like us to examine, let us know in the comments below. Thanks for watching, and don't forget to like and subscribe to help promote a more informed public.